Hello! In this section, we look at what transparency means in platform regulation and what the Digital Services Act does with it.
A conventional way to define transparency is to distinguish three levels. First, disclosure of information. Second, understandability for the broader public. And third, tailoring information to different types of users so different audiences can actually use it.
The overall promise is that transparency supports openness, accountability, and trust, not as abstract values, but as practical conditions for oversight and informed participation.
A helpful conceptual lens comes from Mikkel Fleverbaum, who describes transparency as providing openness, insight, and clarity through visibility management, so that it becomes visible to whom and under what conditions.
Under that view, transparency is shaped by three dynamics. First, selectivity. Platforms and regulators continuously choose what to disclose and what to keep out of sight.
Second, directionality. Transparency creates particular flows of information, and those flows are rarely neutral. They move from some actors to others in specific directions.
Third, interpretation. Transparency is not done when something is published. It is the result of sense making, involving active audiences who interpret, contest, and repurpose what they see.
Importantly, the DSA does not offer one single definition of transparency. Instead, it sets out mechanisms through which transparency should be activated, like expectations around accessibility and machine readability, for instance, in Recital 49.
Before the DSA, transparency already mattered, especially in debates about disinformation and platform accountability. Platforms implemented various measures like fact checking, partnership, policy enforcement, account suspensions, and different reporting practices.
But a key issue was that these transparency measures were often voluntary and platform defined, which made their effectiveness difficult to judge and their outputs hard to compare. A common example is that large platforms published their own transparency reports, like Twitter, which issued biannual transparency reporting for many years. The core problem was not that nothing existed, but that what had to be disclosed and how remained largely understandardized and lightly regulated in many areas.
Even where transparency regulation already existed, like under Germany's NetzDG, comparability and data quality were frequently limited by missing shared standards across industry.
So, what does the DSA is trying to do with its transparency obligations?
A common framing is that the DSA is not a constitution of the internet. It is not primarily about dictating what speech should be online.
Instead, transparency obligations help the DSA ensure accountability of platforms, create openness and trust between users and platforms, and enable a critical public, including regulators, civil society, and researchers, to scrutinize how platforms operate.
In that sense, the DSA focuses on regulating the process, how decisions are made, justified, and reviewable, rather than directly regulating the content itself.
The DSA combines several transparency channels, and they work together.
First, there are periodic transparency reports, where providers disclose structured information about moderation and governance.
Second, there is a centralized statement of reason infrastructure. So day-to-day moderation interventions can be documented and analyzed at scale.
Third, there are transparency tools around terms and conditions, including structured publication and accessibility.
Fourth, VLOPs and VLOCs have to publish risk assessment and mitigation reporting, and they also need to independent audit documentation.
Fifth, there are obligations to maintain advertising repositories, making ad targeting in Reach more legible for oversight and research.
And sixth, the DSA introduces data access provisions for regulators and researchers, explicitly linking transparency to scrutiny. Now, let's map the legal sources relevant to transparency in the DSA.
For reporting, the key provisions are Articles 15, 24, and 42, which scale by provider type and size.
Article 17 establishes the statement of reason database. So for each moderation action, platforms must indicate if the moderation was automated or not. And it must be logged in the database. We will talk about it in a second in more detail.
Article 39 adds a transparency database for online advertising, especially for political ads via ad repositories.
And Article 40 addresses data access, linking transparency to independent research. If you want to know more about this topic, we are talking about it in a dedicated video.
These provisions follow the logic that the larger the platform's reach, the more demanding the transparency obligations, starting with intermediary services in Article 15, then online platforms in Article 24, and finally VLOPs and VLOCs in Article 42. VLOPs and VLOCs therefore must adhere to the most stringent rules.
Let's start with Article 17, which is a new database for moderation decisions.
Article 17 requires a statement of reason for each moderation intervention. This could be anything that changes visibility, a deletion of content, or demonetization of an ad.
That means we should be able to understand why content was restricted or an account was affected.
This matters for fundamental rights concerns, especially freedom of expression. Platforms should no longer be able to remove content or restrict visibility.
What falls under Article 17?
It applies to online platforms regardless of size when they impose restrictions on content or accounts.
This includes more than removal. It covers visibility restrictions, monetary penalties, service suspensions, and account termination, so basically deplatforming.
And it applies in two situations: when content is treated as allegedly illegal, for example, terrorist content or a copyright infringement, and when content is treated as incompatible with the platform's terms and conditions, for example, when it is considered an infringement for what a platform understands as nudity.
Article 17 is broad, but there are some interesting details. There is an exception for irrefutable large-scale and commercial issues like spam and fake accounts, where individuals' reasoning may not be required under the relevant paragraph.
Another exception applies where measures follow government orders. This is referring to Article 9 to 10 if you want to know more. So, what must statement of reasons actually contain?
First, what an action was taken and for how long. Removal, disabling of access, limiting visibility, and so on.
Second, the facts that decision is based on, such as the circumstances of the case and where applicable the source of information.
Third, whether automation was used, so users know if automated contribution was added to the decision.
Fourth, the specific legal grounds when content is treated as illegal, or the contractual basis when the decision is based on terms and conditions. Beyond individual decisions, the DSA also requires structured transparency at system level.
Article 15 frames transparency reporting as an accountability instrument, covering notifications from users and authorities, moderation actions, appeals, and the role of automation.
The aim is to generate insights into platform governance and enhance public understanding and regulatory oversight, provided the information is presented accessibly and clearly.
Article 15 also specifies how reports should look. Reports must be publicly available, clear, and easy understandable. They must also be machine readable, which matters for analysis and comparability across time and platforms. They have to report once a year and VLOPs and VLOCs every 6 months.
Substantively, reports include aggregated figures on active recipients, content removals, appeals, use of automation and AI in moderation, and timeliness of interventions. They also include information about orders from public authorities to remove illegal content or provide user data and median response times. And they should indicate whether decisions were taken on a legal basis or under terms and conditions, and provide reporting on notices from users and trusted flaggers, including outcomes. For online platforms, Article 24 adds even more reporting depth.
First, it extends general reporting obligations with additional transparency requirements.
Platforms must report, for example, on out-of-court dispute settlement activity according to Article 21, outcomes and time needed, which supports evaluating how dispute settlement mechanisms function in practice.
Second, Article 24 introduces the user counting mechanism, which is important because VLOPS and VLOSIS designation triggers stricter obligations according to Article 33.
Third, it requires platforms to submit certain information to support a centralized transparency infrastructure, enabling broader oversight. This links back to the statement of reasons reporting we talked about earlier.
A key innovation of the DSA is that transparency is also structured for further analysis, for example, by researchers.
The transparency database applies to online platforms and supports systemic oversight. It helps monitor moderation patterns at scale.
It also enables, ideally, cross-platform research, for example, comparing how different platforms handle similar types of content.
The Commission must make the database publicly accessible and machine readable, and the data includes statement of reasons fields such as the legal ground and whether automation was used.
Online platforms must submit these decisions without undue delay in standardized format. If you want to try it out, you can scan this QR code.
Transparency only works if it is usable, and that requires consistency.
The effectiveness of reporting depends not only on disclosure, but on whether categories, structures, and the frames are consistent enough to compare across platforms over time.
That's why consistency can itself be treated as a compliance-relevant quality. It helps reveal structural gaps and critical discrepancies.
Methodologically, that opens the door to combining legal analysis with empirical validation across complementary reporting mechanisms so that transparency becomes auditable in practice, not only in law. However, for very large services, the DSA expects more.
Article 42 is modular. It adds reporting layers on top of Articles 15 and 24.
The rationale is straightforward. The largest platforms have more resources and they can generate higher systemic risks.
So reporting is more frequent, at least every 6 months.
Article 42 also forces transparency about human infrastructures of moderation.
Platforms should break down resources by official EU language to show where capacity actually exists.
They also disclose staff qualifications, expertise, and training.
And they must report the support provided to moderators, including psychological support, recognizing moderation as a difficult labor.
Article 42 also pushes platforms to qualify automated moderation performance.
So platforms must publish metrics on the accuracy of automated content moderation.
Crucially, this should be broken down per country, so performance in smaller EU countries cannot be hidden in error edges.
And the report should include error rates, so the limits of automation become visible.
Another key transparency layer concerns systemic risk governance.
Platforms must publish their analysis of systemic risks, like risks to elections or civic discourse.
They also have to report on the measures taken to mitigate those risks. Where problems are identified, platforms must publish how they address them, so transparency links directly to correction.
The DSA also anticipates tension between transparency and security or proprietary information.
Platforms may redact information to protect trade secrets, public security, or to avoid creating vulnerabilities. For examples, detail that would help actors to circumvent safety systems.
But redaction is not the end of oversight. The platform must still provide an unredacted version to the Commission.
Finally, advertising transparency is major DSA innovation.
The purpose is to strengthen oversight and research into risks tied to digital advertising, like scams, manipulation campaigns, and coordinated information operations.
The ad library obligations apply to VLOPs and VLOCs, including certain marketplaces where ads are monetized.
Formally, platforms must provide a publicly accessible, searchable database, typically in a dedicated interface section, and also offer an API, so the archive can be read automatically.
The data must remain available throughout the display period and for at least 1 year after the last display.
The repository must include core information, the ad content, who paid for it, the time it ran, the targeting parameters, and the reach, broken down by member state.
At the same time, it must not expose personal data about the ad recipients. And where an ad is removed due to illegality or terms and condition violations, the content is not archived, but the repository stored around for the basis of the removal.
A current enforcement illustration. The Commission fined X 120 million euros, including for lack of transparency of its advertising repository and related access barriers and design issues that undermine the purpose of the ad repositories.
To close, transparency obligations matter because they make the DSA enforceable in practice and represent a central piece of the regulation.
For regulators, transparency lowers information asymmetries and supports monitoring and evidence-based enforcement. And for researchers and civil society, transparency ideally enables cross-platform scrutiny, comparative analysis, and better diagnosis of systemic risks. Thank you for your attention. We are looking forward to seeing you again in our next chapter on data access under the DSA.